course, as you know now, there is a major showdown that's likely to unfold in the High Court in Pretoria today. The Democratic Alliance is heading there to challenge the constitutionality of the Employment Equity Amendment Act. The party is suggesting that at least one clause in that particular piece of legislation gives the Minister of Labour unfettered powers when it comes to deciding on who gets to be employed and where. Of course, there's a number of issues to be considered here, both legally speaking and insofar as the politics of this is concerned. And for that, let's bring in our guest, the Director of the School of Public Leadership at Stellenbosch University, Professor Zwelinzima Ndevu. Also joining us is Labour Law Analyst Aslam Moolla. Both the gentlemen joining us via our video link. And it's lovely to have you on the program. Thanks very much indeed for making time. Prof, let me begin with you as we take stock of the political machinations at play here. We've heard from the DA spokesperson speaking to our reporter outside court a moment ago, saying the GNU is standing strong. All of this that's happening, the public disagreements, come down to a healthy debate. And Prof, I wonder to what extent you agree with that?
I think we are now getting used to the contradictions within the GNU, that the parties in terms of the policy level, as we would know, are not really aligned, but they tried to save the situation. So I'm not surprised with this contradiction. But what one is not sure of is for how long will these contradictions continue with the GNU holding? So that's the big questions that one would have to ask himself. Yeah.
Right. And at the center of the litigation, Aslam Moolla, is a section of the Employment Equity Amendment Act. It escapes me now, but I think it's 15A, which the DA suggests is at the heart of their problems. Help us break down what this particular section is actually saying and whether or not you reckon the DA is onto something in their contesting it.
Good morning, Ayana. Thanks for having me today. Essentially, the gist, if we were to explain it in simple terms, apartheid had affected access to opportunities for many South Africans. The government created the Employment Equity Act to allow more opportunities. But they're saying progress is happening too slowly because private sector essentially set their own targets. So this contentious area right now is where the new piece of legislation allows the minister to set mandatory specific targets for the private sector. So a practical example would be for a law firm, for example, you got to have a minimum of 4 people in this particular position, etc. Now, the DA is pushing back on that. They're saying, look, they are in favor of transformation, but they believe that the solution is to actually create more jobs instead of trying to maneuver this through employment equity. So that's where the issue is. And that's where we have, on the other side, the ANC is saying, why are you against transformation? So as Professor would also say, is it really a political issue? Is it a legal issue? The courts will have to walk this tight line now. How do they manage the situation?
Yeah. And if it's about perhaps, trying to, well, let me rephrase my question. It seems everyone across the spectrum agrees that transformation is a good thing. The point of diversion is how to get that right. The DA is suggesting this piece of legislation is not the vehicle, if you like, to achieving it. And I wonder, Aslam Moolla, whether you reckon they're targeting the right section of the piece of legislation if, in fact, they're going to achieve their intended objectives.
It's a very good question, Ayanda. So the issue relates to, does this introducing specific targets, is that unfair discrimination or is that necessary for making transformation happening on a faster basis? There is a case which happened in May 2024. I have it open in front of me. Erasmus versus Eskom. I don't know if Professor is aware of this case, but for our viewers as well. A white male was not shortlisted for a position at Eskom, and he took it up to the Labour Court. And the court indicated at the time that the practice of not shortlisting a white male amounted to an absolute barrier, and that was unfair against the Employment Equity Act. So the court right now, Ayanda, will have to look at by introducing specific targets, is that a form of discrimination? Is it going to be an absolute barrier, as the Labour Court ruled? This is the High Court. Ultimately, it will go before the Constitutional Court because it's a constitutional issue. But these are the issues that the judges have to consider now. It is. I personally think it is a healthy discussion to have. It is a good sign of our democracy. I'm sure Professor agrees as well. These are the issues we need to talk about. Transformation, employment equity, it's a hot button for everyone. Everyone has their views.
Yeah.
But this is what keeps our democracy alive.
Well, I'm not sure if you can see the Prof, but he's nodding as you are explaining what you reckon this ultimately means. So at least the three of us might be on the same page. But I wonder again, Prof, whether, members of the GNU have what I've always wondered, which is the political maturity to help us think through what, let's face it, are sometimes very sensitive issues. I mean, as soon as you speak about employment equity in the country, you are summoning our very dark past, the very real difficulties people are still facing today. And without taking a moment to kind of take a step back and objectively look at the merits of the cases being made here, it's easy to be lost in the very subjective feelings that come up when you speak about these pieces of legislation.
We should remember, Ayanda, that in any public institution's perspective or in any public institution's objective is to ensure that they bring policies and legislation that addresses developmental needs or addresses challenges in society that they might be picking up at that particular point in time or problems. And one expects the GNU to collectively agree on a position, on a program of action addressing some of these needs. There is high unemployment rate, and the percentage of unemployment seems to be skewed more to the people that were previously disadvantaged, especially at higher positions, whether it be in the private sector, whether you find that even in state-owned entities, we also find that in companies that the minister has indicated that they've actually done audits in, only below 35% complied with the current provisions of the employment equity plan. So one would then move to say, what do we do to ensure that we address these gaps that we see in the policy provision? And I think the GNU, there must be that maturity to then say, if there are gaps in the policy provisions, how do we address these gaps in addressing the challenges that we want to address? And I'm expecting at that level then to come together and say, we have our differences, because they do have their differences. We would know that these are political parties that comes from very different perspectives. And they would see things in different approaches and eyes. And one expects then for them to then say, yes, there are these challenges. How do you address them as a country with being objective as possible? And I think this provision, it is still lenient. The minister would not make absolute decisions. It says in consultation with the sectors or in reviewing the representation within the sectors of the economy. So I think there is still that opportunity for people to engage. There is that opportunity for the implementation to be in such a way that it does not discriminate against fellow South Africans, but it ensures that it creates parity. And I'm expecting the GNU at that level to be able to agree. We would remember that it is unpalatable to continuously see these disparities, these inequalities that we see in society. And government has a responsibility to ensure that they address them. And I think that the GNU has that moral obligations to ensure that they address these issues.
Yeah, optics are so important in politics, Prof. I'm sure you don't need me to remind you of that. And I'm only prefacing my next question with that because I wonder whether you reckon the ANC and perhaps sectors of society who agree with them on this would have reacted in this way if this litigation was presented by another organization that is not necessarily always associated with whiteness, for example. I don't know, the IFP, for example. If they were the ones going to court today, do you reckon this would be the reaction?
It will certainly, you must remember with political parties, the other thing is political scoring. We've got elections around the corner. While it is a genuine a plea and a genuine attempt to address challenges that society experiences, but political parties would take political scoring points. Had it been a black political party or a political party that normally does not have the history of being led by white people and so forth, and being seen as protecting white privileges, I think if you come to this particular issue, you would have seen the outcry, but it would not have been as loud as this one. It would have been people that do not understand or are not connected to what's happening on the ground. But with the DA, it's being a party that wants to protect or entrenches or continue to preserve white privilege. That's how it's seen, and that is why the issue around transformation, around them being anti-transformation and so forth, it is raised highly. It is because they are a political party that is known to be white. The leadership predominantly is still white, and therefore represents a constituency that would want to see the status quo continue, or at least white privilege being preserved within the country.
Yeah. You know, Aslam, Moolla, to bring you back into the discussion, one would hope that each time a piece of legislation is challenged in court, it is sharpened and it is brought closer to what we all think the Constitution should do, which is to ultimately leave no one behind. To what extent do you reckon whatever happens in this case today will do exactly that for the country's labour laws?
I hope so, Ayanda. You know, when we look at the law, people think it's something in a textbook. That's not how it works. The law doesn't work in isolation. The law is meant to help society to function better, to make sure everyone has better opportunities, etc. So I do not envy the court's task today. They have a difficult job ahead of them. They have to listen to both sides, and the judges have to ask themselves this critical question. Are these specific targets, is it a form of unfair discrimination, or is it going to speed up transformation? And whatever the court's decision is going to be, I can tell you, Ayanda, it's going to affect almost every South African employee in terms of opportunities at work, who gets hired, who gets promoted, what's the general fairness about the workplace. As we started off this discussion initially, employment equity, transformation, it's a hot topic. Everyone has their say on it. But I genuinely believe it is a necessary discussion. It's a good time to have this discussion, and it's a good time to get this going. How can we grow the economy? How can we make sure people have access to opportunities? So yeah, I don't envy the judge's task.
Yeah, absolutely. All right, we'll have to see how it all goes, and it seems precedent setting in one way or the other, and of course an issue of national interest. To both our guests, thanks very much indeed for weighing in. That is a labour law analyst, Aslam Moolla. Also joining us there is Professor Zwelinzima Ndevu, who's the director of the School of Public Leadership with Stellenbosch University. Once again, thanks very much indeed.